I understand and accept that we can't reward persons for flouting planning legislation inadvertently or advertently. That's what happened in this instance. But I suppose the issue is whether a new application could and should be made by somebody. I mean, it's not right or proper that ESB would benefit from this, or indeed Coillte, or the landowners for at least part of this. But perhaps this should be transferred to a local authority to make a new application, with the explicit undertaking that any and all profits that are made from this development go back into protecting the environment of Slieve Bearnagh, both remediating the damage and furthermore protecting the environment of that mountain range, which is very badly damaged by that wind farm. But, you know, two wrongs don't make a right, in effect, is what I'm suggesting.
The Derrybrien wind farm was first referred by the European Commission to the CJEU in 2006, case C21506, and has been the subject of infringement proceedings and the subject of a lump sum fine of €5 million and significant daily fines of €15,000 per day until the terms of the judgment are met as a result of same. To comply with the judgment, the intention was for the operator of the wind farm, an ESB subsidiary, to apply under amendments to the Planning and Development Act for substitute consent, that is, planning permission for development requiring retrospective environmental impact assessment following a request to make the application from the local authority, which is Galway County Council. ESB lodged its application for substitute consent with An Bord Pleanála to the Derrybrien wind farm on the 21st of August 2020. On the 4th of February 2022, An Bord Pleanála decided to refuse the grant substitute consent for the wind farm development at Derrybrien. On the 15th of February 2022, ESB paused the operation of the wind farm at Derrybrien following the decision by An Bord Pleanála to refuse to grant substitute consent. On the 16th of March 2022, ESB confirmed that they have decided to close the Derrybrien wind farm on a permanent basis. The statutory timeframe for other potential objectors to bring judicial review proceedings in this matter has now expired. On foot of the refusal by An Bord Pleanála to grant substitute consent for the wind farm, the EIA regularisation process for the Derrybrien wind farm has ended, and the development is now deemed by primary legislation to be an unauthorised development.
I'm not suggesting that Ireland should flout EU law. It's very disappointing that it has done so and that it's dragged its heels for so long. What I am suggesting, though, is that another attempt to be made to bring Derrybrien into compliance with European Union law, and maybe a better application be made to mitigate the effects, the very negative effects of what has happened. There's a real risk and a worry in the community that in seeking to decommission it, that you're going to cause further damage along the lines of the damage that was already caused. And the worst of it all is, I don't know whether you know the topography of the area very well, but you've Slieve Bearnagh on the northern side of Lough Derg, and then on the southern side of it you've Slieve Bearnagh. And Coillte are proposing to do exactly the same thing on top of Slieve Bearnagh, a blanket bog on top of a mountain. They want to put up turbines. So they're going to endanger Slieve Bearnagh and decommission a wind farm that you can see across Scariff Bay that has created environmental havoc in the past. Nobody's sympathising with that, but I'm saying maybe it's time to cut our losses and actually make a new application, and the state should consider something that perhaps could come up.
The ESB, it's a commercial state company and has accepted the decision of An Bord Pleanála and is in the process of preparing for the decommissioning and the removal of the wind farm. As previously stated, the government has explored all avenues and impacts in this regard and is satisfied that there is no legal basis for its continued operation. The government is committed to pursuing the transition to a climate-resilient, biodiversity-rich and climate-neutral economy by no later than the end of the year 2050, as set out in the Climate Action and Low Carbon Development Amendment Act 2021.